afternoon, and welcome back. My name is Kweku Darfoor of the Darfoor Law Firm, and we're located down here in Fort Lauderdale. We practice in personal injury throughout the state of Florida. Our main office is located in Fort Lauderdale. Today, I'm going to be discussing proximate causation, right? Proximate causation. If you've been to law school, which most of my clients have not, you know what this means, right? But you have to prove proximate causation anytime you have a negligence claim. That includes truck accidents, bike accidents, motor vehicle accidents, slip and falls, anything that's a personal injury claim or negligence claim, you have to prove proximate causation. So what is it? Essentially, proximate causation is the legal cause of someone's injury. So you have to be able to show that just because the defendant was negligent, that alone in itself does not mean that you prevail on your claim. You have to prove that the negligence of the defendant was the legal cause of your injury. So if there was a intervening or superseding act, then the defense would argue that they weren't the legal cause of your injury. However, here's an example, right? And I'm not going to take credit for this because I stole this one from another attorney. But let's say that your neighbor put trash in the middle of the street, right, at night, and the trash collection doesn't come until the next morning. When the trash collector comes in the morning, the garbage is still there in the middle of the street. And because of that, let's say he, gets into an accident because that trash was in the middle of the street and he had to swerve. Well, your neighbor would be the proximate cause because he left that, and that's the legal cause of the injury that was sustained, right? It doesn't matter that it was the next day. That's the legal cause, right? Nothing broke that chain of events to remove that from the situation. So think of it like that, right? There was nothing other than the trash that was the legal cause. And sometimes you could have more than one proximate cause for multiple parties, right? So that's what it is. So in the instance where, let's say, a truck is on the road and there's several other vehicles on the road, and let's say the truck just creates a situation or hits another car and forces the car to veer off the road, and the car crashes. But because the car crashes and veered off the road, the person in the car is scared for their life or whatever it may be, but they get out of the car to try and get to safety on the roadway, right? And another car comes that's coming down the road and hits that person who was trying to get to safety. Or the truck would be held responsibly as a legal cause because they're the ones that hit the car and caused the car off the road. So that's in a nutshell what proximate causation is, right? And that's just in one way how it would apply to a truck accident. So you must establish a direct link between the accident and the injuries that you sustain. In the truck example, right, the direct link is the truck hitting the car, causing the car to veer off, causing you to, or someone to have to, try to walk to safety on the road. The direct link is the collision of the truck to the car, right? And there's different strategies for gathering this type of evidence to support your proximate causation, right? There's dash cam video, there's other witnesses that were maybe driving on the road, there's reconstruction experts that can recreate the crash or recreate the collision. You have possibly cameras in the area depending on where you're at. So there's different ways for someone to gather this evidence, right? It could also be just from depositions, testimony as well. So your lawyer wants to make sure that they gather this, if this is a situation, gather this evidence so that they don't leave anybody that's legally responsible off the hook, right? You may be in a situation where, you get the second impact or the second hit or whatever is from someone that's uninsured or underinsured, but the person that was the legal cause of your injury that impacted you first, right? They may be very well insured, and so, you would be able to recover for your damages that they caused, okay? So there's, some common challenges that you'll likely hear in a proximate causation situation. Those will be that some people don't understand the actual law there, so they're going to try and argue that, maybe the proximate cause, but legal cause, but they didn't cause the injuries because a second person hit them. Well, that's not what the law says, right? The law says if you are the legal cause of someone's injury, right? And there's no broken chain of events, well, you can be held liable for their damages, right? So they'll argue that there was, some kind of intervening, superseding, event that actually caused the injury. And so your lawyer that you have has to be crafty to make sure that they explain in front of the jury what you mean, what the law says, and sometimes even a judge, what the law says about proximate causation, right? Just to drive it home to make sure that everyone's on the same page, and so that when it comes time to awarding damages in the verdict, they make sure that they account for the defendant that was the legal cause of the accident causing your injuries. Thank you for joining. If you liked what I said, if you liked the information today, or you think it provided value for you, go ahead and hit the subscribe button below. And always, if you think you have a case, that you have a question or that we may be able to represent you, feel free to go ahead and call the office, or you can email us as well. There's no charge to review your case. We provide free case reviews.